Welcome to the 5th edition of the Contamination Compass. Contamination Compass is a CLE series that's a program by the law firm McGuireWoods. It provides continuing legal education on topics involving regulatory and technical aspects of environmental contaminants, particularly PFAS. The series includes webinars and newsletters that cover topics such as PFAS testing and treatment, risk assessment, litigation, and emerging state and federal regulations. It's designed to assist legal professionals to navigate the complex landscape of environmental liability and compliance. Today, our topic is PFAS risk assessment and management. I'm Mark Anderson, a trial lawyer with McGuireWoods. Over my career, I've tried a variety of cases, including cases involving environmental contamination, product contamination, cases containing cancer and other health effects were caused by exposures. I'm particularly looking forward to our discussion today because it allows us to focus on steps that happen before trial, even before litigation. In my experience, so often after we've gone through the whole process of a trial, jurors, spectators, but especially clients, are stunned by the time, the expertise, and the resources that are devoted to bringing the science to analyze in retrospect and to deal with the trial process. Often we hear, why did we waste all of that time and money on a trial? What would have happened had we devoted some of those resources earlier? Well, in today, we're going to look at that topic because it's near and dear to my heart, because I think for PFAS, that time is now where people can prepare and prevent. We've got a great panel today to help us understand a little about the science and what's ahead. I'm pleased to be joined remotely by a new colleague in our Washington, D.C. office of McGuireWoods, Andrew Knutson, who joined us from the U.S. Department of Justice Environmental Defense Section. At the DOJ, Andrew was leading cases presenting novel issues relating to PFAS chemicals, including the defense of EPA drinking water standards and health advisories, nationwide multi-district litigation seeking circular response costs recovery from the use of firefighting foams. He also counseled agencies on the development of proposed and final rules under environmental statutes. Here with me in our Raleigh office, I'm happy to have Dixon Snuckles. Dixon represents clients in a wide range of substantive areas, including water and air pollution, solid and hazardous waste, chemical regulation, environmental remediation. And pertinent to today's topic, he is working with clients standing up internal task forces that are designed to help assess the potential risks and to take action. Particularly excited, and I think the focus of our time should be spent with Bob DeMott. Dr. DeMott leads Ramble's health sciences practice, specializing in risk assignment and stewardship for products. He has completed and directed risk analyses of chemical components of a wide variety of products. Likewise, pertinent today, is extensive experience evaluating human health and environmental risks associated with production, distribution, and use and disposal of ingredients and products. In particular, I'm happy to learn a little bit of the science from Bob today, and I hope all of us can come away with at least understanding some of the vocabulary, some of the risks, and some of the steps that we can take as we move forward. With that said, our agenda for today is going to be to identify potential risks, assessing those risks, mitigating the risks, and communicating the risks. Sounds kind of simple. Dixon, why don't you get us started?
I want to begin with an overview of PFAS so you can understand what they are, what characteristics they have, and therefore understand why they've received so much regulatory and public attention in recent years. PFAS are not one chemical, they are a class of man-made chemicals known as per and polyfluoroalkyl substances. A commonly cited estimate is that there are over 12,000 different PFAS chemicals. The National Institute of Environmental Sciences has put that estimate at 15,000. All PFAS share a similar chemical structural trait, a carbon chain with fluorine atoms attached. This structure is an extremely strong chemical bond that is resistant to breaking down, which makes PFAS resistant to heat, water, and oil. These properties make them useful in numerous industrial and consumer applications, including as water repellent for clothing, non-stick coatings for food wrappers and cookware. They're used in gaskets, hydraulic fluids, and firefighting foam, to name a few examples. The same properties that make PFAS effective in various applications also pose unique challenges to the environment and public health. Certain forms of PFAS are highly mobile in water and can be easily transported from groundwater to surface water. Once in the environment, multiple PFAS can be taken up by humans and wildlife through the consumption of water or food containing PFAS. Some PFAS bioaccumulate, meaning the body is unable to break them down or eliminate them. And certain PFAS have been linked to various health impacts. And there are numerous pathways for PFAS to get into the environment. They can enter the environment through manufacturing sites, either through air emissions or wastewater discharges. They can get into the environment through the application of biosolids from sludge from wastewater treatment plants. Airports and military installations can be a source of PFAS in the environment through the use of firefighting foams containing PFAS. And landfills and other waste sites can be sources of PFAS, which can be present in the leachate.
Next, we're going to turn to how do PFAS present potential risks to your business? And for that, we will turn our attention to Washington. Andrew, take us away from the capital and probably the center of some of these risks.
Well, thank you. Yeah, happy to be here to talk about this today. We thought it was worth talking about the source of some of these legal risks. And there may have been a time when there might not have been much to talk about from the federal regulatory perspective, but a lot's changed in the past several years as we've seen a concerted effort across multiple presidential administrations to address PFAS under the different regulatory tools the federal government has. First, under the first Trump administration's PFAS action plan published in 2019, and then a follow-up PFAS strategic roadmap under the Biden administration, which they published in 2021, and it's been several years implementing. And then most recently, a slate of policy actions that Administrator Zeldin announced earlier this spring for the policy priorities of the second Trump administration. So I think the most significant change we've seen in the federal landscape has been EPA's action under CERCLA, the federal Superfund statute, to designate two specific PFAS compounds, PFAS and PFOA, as hazardous substances under that act. Now, this is actually the first time that EPA has used its authority to do that. Generally, CERCLA's reach extends to substances that are regulated under other environmental statutes, but PFAS and PFOA didn't fit that category. So EPA used its authority to make a discretionary finding that these two substances are hazardous under the meaning of the statute. And that had two real immediate impacts. The first is just to require reporting of any release above a threshold quantity for these two substances. But much more significantly, what this listing does is it creates liability for any response costs incurred in responding to releases of PFAS and PFOA. So this opened up a cause of action for not just EPA, but for private parties and for states to pursue cost recovery and contribution actions against responsible parties under the Act, which we'll talk about more later. Also under the Safe Drinking Water Act in 2024, we saw EPA promulgate a set of national drinking water standards limiting concentrations of 6 different PFAS in public water systems. For PFAS and PFOA, these standards were set at the lowest level that EPA found can be reliably quantified. It was an extremely low level of 4 parts per trillion. And there are also standards governing 4 additional PFAS, regulated both individually for 3 of those compounds and for the mixture of those compounds together in the form of a hazard index that essentially measures the combined concentrations of those and accounts for what EPA found were additive impacts. Now, those standards are still being challenged in the DC Circuit right now, and currently the new administration is stepping back from those standards somewhat. With respect to the hazard index part of that rule, EPA announced that they're going to take a reconsideration rulemaking to reconsider the decision to regulate those 4 PFAS. And they've also actually moved for summary vacatur from the court of that part of the 2024 rule. Now, with respect to the PFAS and PFOA standards, EPA announced that they do plan to continue defending those standards, but they plan to undertake a rulemaking to extend the compliance period from 2029 to 2031 for those standards. But they remain in effect for now, and even for companies that aren't regulated directly as public water systems, these standards still present a risk. One, because regulated systems will be looking for help covering their costs to comply with this rule. And 2, because these drinking water standards actually set minimum levels for circular cleanup standards where a circular response action is underway. Third, under the Toxic Substances Control Act, we've also seen EPA issue a rule requiring reporting of information about PFAS manufacture and importing. Specifically in 2023, EPA issued a reporting rule under Section 8A7 of that statute. And it requires that any person who manufactured or imported PFAS for a commercial purpose since the beginning of 2011 has to submit information to EPA regarding the uses, production volumes, byproducts, disposal, exposures, and any existing information on environmental or health effects from those PFAS. Now, that rule is not just limited to importers or manufacturers of PFAS chemicals directly, but also includes articles containing PFAS and doesn't include any exemptions for research and development, impurities, byproducts, or small manufacturers. And it takes a fairly broad view of what PFAS are covered. Unlike the CIDWA rule or the CERCLA designation, the TSCA reporting rule, instead of listing specific compounds, defines PFAS based on various chemical structures. Under the Clean Water Act, we have seen EPA exploring the development of effluent limitation guidelines for various industrial categories, which, if EPA issued those, would set minimum technology-based standards for permit limits in the MPDES permits that states issue. EPA had been close to proposing an ELG rule for PFAS manufacturers, but that was withdrawn earlier this year and is now slated for proposal next January. But in the meantime, we've seen EPA make efforts to encourage state permitting authorities to include monitoring and limitations for PFAS in the NPDES permits they issue. Specifically, in December of 2022, EPA issued guidance that recommends certain measures for industrial direct dischargers and categories that are known or suspected to discharge PFAS. That includes things like organic chemicals and plastics manufacturing, metal finishing, electroplating, landfills, and pulp and paper mills. That guidance recommended that these permits include monitoring at least quarterly for PFAS, and also recommended that the state permitting authorities use those monitoring results to develop permit conditions. And then finally, I should mention that under RCRA, EPA has proposed to list 9 specific PFAS compounds as hazardous constituents under that act. The effect of that would be that for facilities that are regulated treatment, storage, and disposal facilities, that if they become subject to corrective action, those requirements would extend to PFAS for assessment and cleanup. It's unclear for the moment what direction the current administration will go on that proposal, but their regulatory agenda predicts the final rule in April of next year. Dixon, I'll turn it to you for the state perspective.
Sure. And while there has been some movement on the federal side, many states do not believe that the federal government has been aggressive enough in regulating PFAS. Over 30 states have enacted their own PFAS regulations or policies. These include adoption of state-specific drinking water standards. New Hampshire is an example of a state that's done that. States like California, Maine, and Minnesota have instituted bans on intentionally added PFAS in certain consumer products. This patchwork of state laws creates an enormous burden on manufacturers, suppliers, and retailers who operate or market their products in multiple jurisdictions. And we don't have time to go over all of the state regulations of PFAS, but in our newsletter, Contaminants Compass, that comes out monthly, we do try to highlight significant state regulations that are enacted to keep everyone abreast of those. Turn it to Andrew.
Yeah, so where have we actually seen litigation risk so far? Well, the first major litigation activity dated back to the early 2000s, and we saw major activity by state AGs against manufacturing facilities, I think including the states in Minnesota, Delaware, Ohio, and Michigan. And these early cases resulted in settlements that were roughly in the range of the hundreds of millions of dollars. Since then, we've seen really an explosion of further litigation, including by private parties, and a really active plaintiff's bar exploring potential theories of liability from PFAS contamination. I think the highest visibility of these cases has been the multi-district litigation consolidated in Charleston, involving exposure to one specific PFAS-containing product, which is aqueous film-forming foams, or AFFF, these PFAS-containing firefighting foams that have been used to combat things like jet fuel fires and other really intense fires. The litigation over these cases has grown to, I think, about 13,000 cases consolidated under this MDL, and it includes a really broad range of plaintiffs, everything from water supplier districts to state attorneys general pursuing cases, to individuals that have personal injury or property damage claims. And they're claiming damage through all different kinds of exposures, through direct exposure to drinking water, through exposure to the foam itself, through firefighting and firefighting training activities, and through the PPE that is worn during those activities. And this case has resulted in some really significant settlements between the manufacturers and the water providers to date, with the largest between 3M and the water providers valued at over $10 billion. And the litigation is in the process of working towards a personal injury bellwether trial that would test out some of the personal injury cases that have been advanced as well. Outside of the MDL, we've seen a lot of litigation aimed at other sources of PFAS. One common target is cases based on PFAS contamination in drinking water. There we've seen plaintiffs asserting theories of negligence, nuisance, product liability, and failure to warn. And plaintiffs including, again, water providers or individuals who have claims of personal injury or property damage. We've also seen a growing area of litigation that's aimed at the producers of consumer products, those who don't necessarily produce or process PFAS and may not even know that there's PFAS in their products, but are facing litigation anyway, based on either exposure to PFAS in those products or increasingly theories of consumer fraud or deceptive marketing. So these may be products that are labeled as healthy or clean or all natural, but have some PFAS inadvertently contained in them. We've seen plaintiffs advancing theories that they were injured by paying more than they would have paid otherwise if they had known about the presence of those PFAS. And then finally, I'll note again, with EPA's designation of PFAS and PFOA as hazardous substances under CERCLA, that's opened up a whole new avenue of litigation for cost recovery or contribution by private parties and states for any costs incurred to respond or remediate to PFAS contamination. It's particularly attractive for, I think, for water providers who, again, looking at the impending deadline for compliance with the CIDWA drinking water standards, are facing the squeeze of having to install technology to comply with those MCLs and looking for help in covering those costs. So the designation of PFAS and PFOA opened up the possibility of strict liability claims under CERCLA, which imposes liability not just for operators who might have used PFAS, but even as far as any past or present owner of a site where PFAS was released. EPA has issued guidance saying that it plans to use its enforcement discretion to avoid enforcement against so-called passive receivers, folks like farmers, municipal landfills, and water utilities. But EPA's guidance about how it plans to use its discretion doesn't extend to other parties who might use these cost recovery actions to pursue cost recovery claims. Dixon, back to you.
Sure. The last risk we want to talk about is the transactional business risks that PFAS may pose to your business. PFAS are presenting significant challenges for transactions involving active and legacy industrial sites that have been impacted by PFAS. The American Society for Testing in Material, ASTM, develops guidelines and standards for phase 1 environmental assessments for real property. In 2021, ASTM updated its guidelines, which now say that PFAS should be assessed as a business environmental risk. Including PFAS in your phase 1s is no longer optional following the designation of PFOA and PFOS as hazardous substances under CERCLA. Compliance with ASTM site assessment standards can satisfy CERCLA's all appropriate inquiries due diligence requirements, which is necessary for buyers, lenders, and sellers to qualify for certain liability protections under CERCLA. The presence of PFAS at a site may also impact how a deal is structured and what liability protections may be needed in the deal, including indemnity provisions and the crafting of insurance policies.
So now let's turn to a little bit about how you assess risk. But as we turn to Bob for some of the science, I'm reminded of a picture I took in a general counsel's office that I keep to remind myself where companies, and we have some of our clients on the webinar today, where companies sit. And again, with my theme of let's look at this prospectively, this general counsel had a quote up on his wall that I've always remembered that says, prevent a complaint from becoming a case from becoming a cause from becoming a crisis, and a crisis from becoming a calamity. Some of the settlements we're seeing here, some of the potential litigations are already full-blown calamities. So Bob, what can we help our clients do? What can our clients do to assess their risk? And most importantly, to take action to keep from being involved in a crisis or a calamity?
Well, we can certainly help minimize the risk. Of course, as you mentioned, Mark, there's a lot out there already. But I'm going to start by pointing out how broad you have to evaluate the different possible sources of PFAS, whether it's in the environment or in products. Don't forget that the incoming water, air, and the soil around the buildings where you operate may very well have background levels of PFAS in them. And with today's technology for making the measurements that we can, particularly in water and similar media, you can actually be picking up that background contributions that you may be chasing all over the plant going, where is that coming from? And it's coming from your incoming water. The next step is that there are plenty of products where PFAS and similar compounds are intentionally a component in the product. They're either reacted to form a different PFAS or a polymer, or they're mixed together and not reacted or changed. The next one that we see a lot come up when we're doing audits is the idea that there are byproducts from the processes. These can be process aids. There are things that might be sprayed on a piece of machinery or a roller or something like that, or maybe used to release things from a mold. And also the equipment itself can be contributing, where you think about if you have PFAS containing or Teflon containing bushings on a piece of conveyor equipment or something, and little bits of that are ending up transferred onto packaging or onto materials. I mentioned packaging because that's the last of my point on the slide I want to bring up. Packaging, where you are using recycled content, and we do so for very important reasons related to sustainability in that, but that content that went into that recycling is something to be very aware of, and certainly polyfluorinated materials can be in there. So you can have both intended use of PFAS for packaging purposes for its qualities that it has, and it can turn up in the waste streams. So next slide, please, Mark. So there's a lot of PFAS that may be in the products or in the environments, but I want to talk about making those into groups that you can deal with a little bit better. So there's the PFAS in a bottle. These are the generally liquids at room temperature, and these are the things that might have been in the original product formulations for PFOA and PFOS, like AFFF, are also used as chemical intermediates in a lot of production today. So these are the PFAS that are actually of environmental relevance. These are the things that can move through the environment, and Dixon pointed out the different pathways that can be involved. The difference I want to show you between the legacy and the newer compounds is important because some of the properties that we deal with, that is the persistence and the toxicity, are different between, let's call it the legacy or the original PFAS, like PFOA and PFOS. You'll also hear the term C8 or long chain. And those are the old ones that are now out of production, out of use. But because of their persistence in the environment, they're certainly still out there. The short chain PFAS are the replacements that were used in many applications and in product production. And they generally, and I realize I am generalizing, they are generally less persistent. That's a pretty good generalization. They're also generally less toxic. That depends on specifically the compound of interest. But as a generalization, that's the point of why they were used as replacements. Now, the very bright line I want to draw is the PFAS as a solid, and make sure that you're aware that the Teflon tape that's out there, the piping that's made out of PVDF and PTFE, these do not move through the environment the way the PFAS from a bottle does. And while we've seen a very intentional grouping of PFAS as a unitary thing, those are two extremely different, both toxicologically and environmentally, groups of PFAS that are out there. Next slide. So while I am a product stewardship practitioner, I am a toxicologist by training. So promising not to go too far into the liver enzymes, I want to give you a real brief explanation of why there's such big differences. So the 12,000 PFAS are not in fact one, because they operate depending on their chemical structure and how they can interact with cells in the body through different mechanisms. And I've given you 3 examples here. Yeah, the one that gets the most attention and ends up at the very low values, as Andrew pointed out, even below detection limits for our health-based values, are the PFOA because of its observed effects on the immune system, okay? But go down that list, it's hundreds of fold less toxic or potent when we start looking at a different compound, the PFBS, which is a shorter chain molecule, and it has a completely different mode of action on the production of hormones, okay? Look at one more where it's actually interference with detoxification mechanisms or damage to liver cells that we see for PFBA. And you could go on, maybe not 12,000 times, but certainly many different modes of action. And that's the basis by which PFAS are not toxicologically the same. I'm going to go back to that polymeric thing that I mentioned of why does the Teflon tape or the O-rings not have the same toxicity properties. It's because those molecules are actually too large to go inside your cells. So they don't have the same possibility even of having these modes of action because they simply can't get in there. Also, those backbones that Dixon mentioned with regard to the carbon and fluorine, your body, your enzymatic processes can't break them apart very well. So you end up with very limited reactivity or portions of the molecule in which all the chemistry can happen that could result in some type of toxic response. So all this points out the variability and the importance of not treating PFAS as one, because the next slide I want to go into What happens if you just throw up your hands and say, I don't have a toxicologist with me today, let's just treat my PFAS like your PFAS? The rabbit hole you go into is that the measurements of PFAS are going to be found widely in the environment, and you'll end up being treated in a worst case scenario. If we just assume the worst PFAS, and we see the idea that the MCLs were set for PFOA and PFOS, and that's the mindset that many people have, is that PFAS are like this. It's not the O-rings and the gaskets. The polymeric materials are not reasonably similar to the PFAS that we find as drinking water contaminants, and treating those as similar ends up putting a lot of liability and risk on certain product producers where that's not their PFAS. Okay. Well, how do you find out what's your PFAS? Supply chain inquiries, that sounds really easy. You just call up your supplier and say, what's the PFAS in there that did you use, and can we please substitute it out tomorrow? And they'll tell you yes. Either that, or they'll send you a nice letter, from their lawyer that says, we don't know what you're talking about, we don't know what the definition of a PFAS is, and we're sure we don't have any in there. Expect also intellectual property and confidential business information issues to arise with supply chain inquiries. The other thing, and from having done audits, I'll tell you, this is not disingenuous in any way. Because of the complexity of supply chains, often the suppliers you reach out to will not even understand where 2 steps further along the supply chain PFAS might have entered as a process aid, as an unintentional component, or as an ingredient. So these are all complexities that you've got to be very careful to try to corral and to ask the questions that get there. One of the way to get there, I'll tell you, is get out in the facilities and on the sites for the environmental sites and get your eyes on. Because a lot of times the mystery that you're looking for isn't in the film that's being prepared to put the food product in. It's in the cleaning product that was on the equipment that was used to get the last batch off. So it can be very hard for someone in the facility to recognize where they should be looking for sources of PFAS. Once you know where they are, how are you going to manage these things? Restricted substances lists can be very effective because it's directed. You can give people a list of things and say, I don't want X, Y, and Z, or the specifications for what you supply to me, must exclude the following things. And that can either be in the form of a policy or actually chemical lists. You can request certifications from your suppliers. And of course, these are just as good as the people who wrote them and the paper they're written on. They can be very effective. They can also be less reassuring than you might hope. The process and reviews and audits are really important to get out there. As I mentioned, the example of seeing something in the plant, but it's also a way that you communicate to your suppliers that you're going to be engaged and you're not going to miss something. So I would emphasize that where you're dealing with this type of supply chain inputs, be observed to be engaged and participating in getting out there and seeing what's going on. And as we move to our next section, the last thing I'll say, the obvious thing is simply go out and test, and you can identify all the PFAS you need in any product you need and know what to do about it, right?
So yeah, I see your next slide, and I think all of us have a similar question, Bob. We've learned enough to know that apparently PFAS is everywhere and everything. And at least in the general public, everybody's now believed that PFAS is horrible for you. It's going to be a big problem. So lots of clients are out there going, why would we test if we're going to find it? And if we find it, people are going to know about it, and then we're going to get sued. Help us understand that.
Okay. For every reason there isn't to test a certain site or a certain product, there's reasons why you might have, even as an attorney, might take the exact opposite and see the advantage. When we're looking at either optimizing remediation strategies, knowing what specific compounds you're dealing with and what interactions among them may be there or out there, but more significantly useful is often the chemical fingerprinting and being able to identify sources. And my favorite is excluding sources that we tend to do and have a lot of fun when you are anticipating that it came from facility A and is contributed to the groundwater plume that's now going underneath the well for a particular town. And you can be the one to bring forth the chemistry that says, that's not your fingerprint. That's a good day in our world. And it's where the science has provided concrete reassurance to a client. So you have that advantage of being able to, in some cases, identifying that there are alternate sources that are not your environmental contributions. Also, the degradation patterns can be quite useful for demonstrating that if you do have a certain source of impacts, that you know that's not the one that has gone to a certain point down gradient or to a certain aquifer, because again, the degradation pattern doesn't look like what you use in your products or in your facility. Turning away from the environment to the products, the advantages of where you can make effective use of testing and be when you want to find unanticipated content, like you're concerned about supply chain certifications, and you want to say, we'll be testing every 100th unit on the dock at Long Beach. Even saying that or having that as a program can be very effective for helping manage the risks. And finally, this is the most sciencey, the geeky part I'll get. Everybody thinks we should just substitute PFAS. If it was that easy, of course, we would all just substitute PFAS. But having the testing abilities and being able to identify different compounds and their breakdown products especially is critical to being able to do the substitutes. So Mark, there's your reasons of why you would do this.
Okay, so how do we do it?
Oh, it's easy. And I'm only being slightly facetious for water. We do have extremely sensitive methods available today for many of the important environmental PFAS in water. The dissolved forms are relatively easy to analyze and to have approaches to do. Next up the list that can be somewhat easy is soil and sediment or other solid matrices that are fairly similar or homogeneous. The PFAS will bind to them in a reasonably consistent manner, and we have ways in the laboratory to get the PFAS off of the soil or the similar material and measure it. So the hard one, and this is the one everybody wants. Can't I just test my product X and demonstrate that there's no PFAS in it, or what the PFAS are I know are there just from the water supply? The answer is that most articles especially are so complicated that finding what to test and having laboratory methods to test them is not A, easy, or B, in existence today for many of the different polymeric materials that are the PFAS that are used in many applications. So it's not near as easy as everyone would hope, or the expectation is. Slide. Go ahead and advance so I get all of this on one slide. There you go. Once more, please. I won't go through all of this in detail, but I want to show you in 7 years, between 2018 and today, back then we had a water-based method from EPA where you could quantify 14 PFAS. You could get to the part per billion range for water testing, and maybe on a good day, part per million range for certain products that were amenable to analyses. Jump ahead to 2025. The good commercial labs out there can measure 100 different PFAS and more in water and soil. And now we're starting to get to the more modern, the replacement PFAS and more of the materials that are actually in use out there. And we can get to part per trillion range sensitivity for water and subpart per billion for some of the solids. This has changed dramatically what can be found, and that creates all the complications that Mark, you alluded to of, we're gonna find something. Now what do we do? Okay, next slide. But there is one worse twist. What if instead of measuring PFAS specifically, like PFOA or PFOS, we just measure fluorinated stuff? There's a proper scientific term for that. It's called indirect methods. And they're useful because I mentioned there's so many different PFAS and we don't have analytical standards for them all. It's hard to measure some of them and extract them from materials. So there are these indirect methods which essentially just say how much fluorine's in there. And you all will trust me, right, that all that fluorine must have been from a PFAS. Of course, that's not the case. There's lots of other reasons that fluorine may be present that are non-PFAS. And then, of course, the change in definition of PFAS changes that every day, too. But something that's easy and useful can be put into regulation more readily than, well, when a method becomes available, could you please measure for X? So if you measure for these things called like total organic fluorine, it's now gone to the step of being a very specific regulatory compliance criterion for at least a couple of the states. California and Minnesota said, if you have 100 parts per million of this total organic fluorine in your product, we're going to presumptively determine that that's from a PFAS. No need to worry your head about what PFAS it is or where it came from. You got to deal with it. And
so let me ask you a question about the slide that says presumed to be an intentionally added PFAS, not just we're going to presume PFAS, that you intended it to be a part of the product. Is that right?
Yes. And of course, that's relevant to the regulatory compliance too, because most of the state regulations that Dixon pointed to do distinguish between intentionally added versus unintentional content that you had no way of knowing was there or wouldn't, like the environmental contamination from the water source in your plant. Okay, we can jump ahead.
All right, so now I'm interested from all of your perspective, from Dixon, Andrew, Bob. Now we've done what those of us maybe on the client side of the lay world are worried about. You've tested, and you've got PFAS. What do?
Well,
who's gonna start? Dixon?
I'm going to start this section here, and I know everything you've heard about the business litigation regulatory risks may seem overwhelming, but there are some practical steps that you can take as legal counsel or as an EH&S personnel in your business to help manage and mitigate these risks. One of the first things you should consider doing is creating a PFAS task force. And that may include experienced outside counsel, environmental consultants with subject matter expertise, and internal personnel from relevant areas of the business, including EHS and procurement and plant managers. And the earlier that you can create this task force, the sooner you can help identify and mitigate potential risks to your business. And regardless, though, if you develop a formal task force or just have someone in your company who's focused on this issue, your company needs to develop a system or process to stay abreast of the federal and state regulatory developments, the compliance obligations and deadlines associated with those. You should also be developing a program for auditing your company's processes, materials, waste streams, and suppliers to identify and monitor PFAS use and releases, whether that use or release is intentional or unintentional. You should consider updating contracts with suppliers or customers to help allocate liabilities and update internal policies for tracking and managing PFAS in your supply chain or waste streams. And then just one more plug for outside counsel, shameless, I know, but as your company is working to identify and evaluate these potential PFAS risks, you'll want the freedom to have frank discussions as you investigate and study these potential risks and develop different options for managing and mitigating those risks, and as well as considering the costs and other business considerations. And so while the attorney-client privilege is not foolproof, it does give your company the best protection it can against having these frank discussions and this work disclosed to third parties down the road.
Before we turn to what an expert can do to help, Andrew, I want to put you on the spot, just coming over from justice. What are your thoughts in terms of what, here we're teeing this up, your product or waste contains PFAS. So this is directed to manufacturers, owners. From your perspective, what particular things should they be looking to do or be worried about?
Well, I think one, once you identify, PFAS, let's say on your property, you need to consider whether you have any potential. I would say consider any potential exposure to circular liability. Is there examine whether there's some risk that this could extend to some neighboring property, and you might be caught up in remedial action related to that site. Yeah, I think that to me, given the growing risk of circular liability as that area of law continues to expand and plaintiffs begin to explore cost recovery actions, is going to be a significant source of risk to folks that I think they should monitor closely.
So that's your number one. Is that where we go back to testing? Whether, I know we're going to talk about process changes, but is that an area where maybe then it does make sense to do a deeper dive and see if you can find fingerprints, see if you can find out? Sometimes at least in jury trials, I talk about the first one to the truth wins. Once you know you have it, does that merit a serious investigation into exactly what the it is?
Yes, because of, and I agree with Andrew that the most complicated litigation is going to be the cost recovery and allocation because of the complexities of PFAS that are out there. And the good news about having all these different degradation products and mixtures in the that are formulated is you do get these distinct fingerprints. So you have some fighting chance of being able to evaluate and say, this plume came from site A, but this other plume came from site B, and that's not our material, or that's not related to our disposal activities in that. Right. So that can be very effective towards managing your risk.
So then I guess the next part is understand where you are and try to fix it going forward. That something that you get involved with from time to time?
We do, but more broadly, I'll just give you a few things. On the stewardship end, what do you do to at least limit forward-looking liability? You can control the PFAS that are in your supply chain, right? Make sure that the things that are notably under regulatory scrutiny or notably toxic and persistent, that you get them out either with some type of a substitution for using non-PFAS alternatives. A good example would be the switch to non-fluorinated firefighting foams. And there's a whole hour we could talk about the idea of accepting a less efficacious firefighting foam, which is what the non-fluorinated ones are. But we see an interesting mix of policy and science there where we don't want the fluorinated materials, so we're going to get rid of them, even though the military has now made that change. You can also really focus on supplier transparency and demands. I gave a few examples of things we do in audits. This is helped by two things: Europe and the American public. People really do believe that there should be a lot of transparency, and most folks in the US are surprised at how limited it is under our regulatory programs. That's not the case in their EU and their REACH and their regulatory strategies, which are going to come more and more across because, again, people want that transparency of what's in my Fruit Loops. Okay, product recalls, and by that I really mean more of takebacks. If you know that, and one example that we worked on was certain fire extinguishers had been formulated with a material that, when it was originally specified, was just fine, but then became on essentially a regulatory hit list. It had not been prohibited, it wouldn't have been non-compliant to send it out, but it was a situation where the last thing I need is a lawsuit over this because people hang on to fire extinguishers for many years. And it could very well be prohibited, quote unquote, by the time this product gets used. So let's leave it there and move ahead. Oh, the heat map. So this goes to Mark's idea of the calamity. The matrix here that you want to just kind of think about, the type of exposure or the handling and use is on the top axis, and then down the side is the different exposure pathways that may be relevant. And we're not going to go through all these boxes, of course, but it's for you to have as sort of a cue to think about, well, when I have very limited potential discharges in that, the boxes on the upper left are the you can sleep well at night boxes, and the boxes on the lower right are the ones that are the calamity boxes. So you can think through and just ask yourself the questions that are posed on each of those and the axis on the top and the side of this matrix, and help. Of course, you want to move from the red towards the green and where you can find options to make changes that push you kind of up and left. I'll leave it there for today.
I might have to double click for a second on that. How do you go about making those changes? You never want to be down in the bottom right in the red, but what do you do to get you up to the green or to the white? If you're day to day, if you're somebody whose boss is watching this CLE and then says, "Well, Bob, make it be. Get us up to the green."
Okay, so let's look at on the environmental side. If you're at a plant and you're thinking about your discharges to the public, the POTW, the wastewater system, think about pretreatment, right? If they're going to start asking you about what's in your wastewater, and maybe we're going to need to put that on your permit next time you renew, maybe it's time to think about pretreatment at the facility. So you move from a wastewater where your discharge could be, lower and brighter, and you can move that up towards the green by implementing those type of approaches on the environment. On the products, go back to my example about substitution, and think about using materials that are contained within parts so they're less accessible. An example there would be the very last PFAS that we will probably see in use are the ones that are used within computer chips and computer components, because they are literally sandwiched within electronic equipment. They are not going anywhere, and no one's in contact with them. And because they're contained within something, they can't even really get out through being heated or leached or something like that. So there's examples where you can use specialized applications or specialized substitution approaches and environmental strategies to move yourself up and left.
So kind of a few topics in our last, we got about 7 minutes, but next, I'm sure the downside of this webinar is that anybody who is on it probably understands that there are risks, probably is worried about what we need to do. And so we thought maybe we'd leave them with some thoughts on how do you communicate PFAS risks to the decision makers in your business. I was only kind of kidding when I told you earlier that I run into clients who say, why should we test? We don't want to know that we have PFAS. There are others where people, we see so many seminars or things that our slide ourselves think it's like the next asbestos. And I hear from some clients, well, this is just a lawyer industry. You want to hire, lawyers are going to sue us and you want to charge us all this money to do things. Well, how do you best really communicate these risks with a plan towards what should we do about it? I'm sure people would be interested in everybody's thoughts. Maybe we have a little bit. Our next is we're looking at the regulatory environment. That's, again, kind of an Andrew Dixon thing. Dixon, you want to start us with that?
Sure. Yeah, I think it's just really important for companies who are aware of the risk and may have potential liability exposure to understand how rapidly evolving the regulatory environment is, and that you really need to stay abreast of these regulatory developments and get frequent updates and understand how, even regulations that were passed during the Biden era, the hazardous substance designation, that's still in place, but the MCLs for 6 PFAS under the Safe Drinking Water Act, well, the Trump administration pulled back on that, to withdraw 4 of the MCLs for certain PFAS. So, and then under the TSCA TRI reporting requirements, there was a deadline that I believe was coming up under the original regulation that the Biden administration enacted, and the Trump administration has delayed those deadlines significantly. And so you could be working towards a certain deadline and then it gets moved, or it could be accelerated, especially with on the federal side with the administration changes. And then on the state side, that's really unpredictable. You've got states who have been really aggressive, beginning in the early 2020s. But now other states are kind of filling in the gaps that they're seeing as well. So it's a really complex regulatory environment, and you need to have someone either in the company or outside the company who's monitoring this for you and can help you set up your compliance program.
So, Andrew, I'm going to put you on the spot again, which is our man in Washington, straight from justice. We also hear people saying, well, Trump's in office, they're going to roll all this back. We shouldn't worry about it. PFAS ain't going to be bad anymore, or somebody's going to say it's okay for you. Does that mean you, like our previous slide, you just put your head in the sand and you say, I'm just going to wait it out?
Yeah, that's certainly not the case here. And I agree with what Dixon was saying. I think the takeaway from this regulatory environment is that you may see some changes in the requirements of these Biden era regulations, but overall they're not going away. We're still going to see federal action on PFAS under a whole host of different environmental statutes. With respect to the drinking water standards, the standards for PFAS and PFOA, will remain, albeit with a longer compliance timeline. EPA has delayed the reporting period for the TSCA reporting rule, but has not lifted it. And, we expect it will go forward perhaps in a more limited form at some point. And in general, there seems to be, at least some level of bipartisan agreement on the need for federal action to address PFAS. If nothing else, just to provide a uniform level of regulation across the nation and avoid, an excessive patchwork of different states taking different approaches. So I think we will continue to see federal action, and not to mention that, one of the unique things about the CERCLA hazardous substance designation is that, that takes the risk of liability, somewhat out of the federal government's hands, and opens up the possibility for cost recovery and contribution actions by private actors too. So that's not dependent on who's in office in Washington anymore. That's private plaintiffs pursuing those claims.
That's really helpful. So in our last couple minutes, let's do a lightning round of things that we suggest as, back to our title here. If we're going to risk assessment and management, what's the one thing people should take away? I'll go back to, as a trial lawyer, I always suggest people think 10 years from now, you're sitting on a witness stand and you're being asked to explain what you did in 2025 and why you did it. Can you have a construct? It may not have to be every single piece of testing that Bob suggests, but, were your actions reasonable at the time based on the information you had, or were you the guy with your head in the sand? You want to be reasonable based on current science. Bob, thoughts?
I would say that the key is to act on what's known and reinforce what's mythology. And where I'm going with that is the idea that PFAS is not a unitary thing and the risks are not the same. And the more we adopt that and just say it's a PFAS case, we should have gotten the PFAS out, that is a much different ask and much different risk profile for someone who makes O-rings that are used within some type of hydraulic equipment versus someone that makes firefighting foam out of fluorinated materials.
Anything to add, Andrew, or then we'll give Dixon maybe last word?
No, nothing to add from me.
I would just say, as Mark's been harping on it, you just, instead of waiting for the calamity, being prepared in advance, developing a program within your company or a task force can avoid a lot of problems for your business, not just on the litigation side, but just operationally and how your business is running. If you set up these programs, you can avoid a lot of different problems that can be facing your company. I mean, you're not prepared to or aware of the state regulations, and you haven't prepared for those to comply with those regulations. There are going to be significant supply chain disruptions that your company's facing if you're still using suppliers that have PFAS in their products. There's a lot, certain PFAS are receiving a lot of attention, especially in certain consumer products, and you could be facing reputational brand damage as public perception of PFAS is really negative. And then obviously it complicates transactions significantly because everyone that wants to, it's like a hot potato, everyone doesn't want to be carrying the liability at the end. So it really is important that you take the steps now while you can to prepare your company for all these changes.
So as we come to the end of our hour, on behalf of McGuireWoods, really like to thank Bob for coming and joining us. We had some great discussions live, but also surrounding this meeting that I think will help us. He's been valuable for a number of our clients. And thank you all for tuning in. If you found this interesting, you can do all the things, like us, follow us. We have a newsletter once a month. We try to keep them, there are topics that are relevant to all of you. So thank you.